All right, good afternoon, everyone. Hope you're all doing well. My name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin LLP. We are the employment lawyers. Welcome to our Thursday afternoon edition of Employment Law Q&A. This is a question and answer session. You ask your questions in the chat and you get information and advice from me, an employment lawyer. I'm here to solve your workplace problems, answer any and all questions you have with respect to your employment. I don't care what the issue is, whether you're dealing with a termination or maybe an unpaid leave, whether it's a vaccine issue, maybe you've been laid off from your employment, if you're being bullied at work, if you have a pension question that's related to your work, by all means, ask away. This is your opportunity to get on the path to resolving your workplace problems. Listen, we all have difficulties at work, whether it's at one point in your career or another. We have maybe a hard time with a boss, or we're dealing with a termination or a layoff. It happens to all of us. There is nothing wrong with that. It's a part of anyone's career, but you need to know as an employee how to handle those situations. You need to know what your rights are. And you need to know, especially if you are being terminated or being put on an unpaid leave of absence, you need to know how to respond to a situation like that. A lot of times, employers will let an employee go and pay the incorrect amount of severance. A lot of times, employees will be put on a layoff or put on an unpaid leave when an employer actually has no legal right to. So if you have any of these questions related to the work this afternoon, we're live on air for the next half an hour. Please go ahead and ask your questions. Again, there are no wrong questions. We will help you resolve those problems. Now, a couple of pieces of contact information, as you probably saw on the screen. If you want to contact us off air, if maybe you're a little too shy, a little too bashful to ask your questions online, if you want to get into more detail, that is okay. That is what we are here for. First piece of contact information, employmentlawyer.ca. It's up on the screen right now. That is our website. It is the main place where you have all of our contact information, all of our details. If you want to reach out to us, employmentlawyer.ca is the first place to start. Not only does it have all of our contact information, it also has a ton of resources, articles, video clips, links to our employment law TV show and to the radio show, really just a ton of information with respect to lots and lots of different issues under the employment law banner. You can also email us or call us. The number is on the screen right now. You can also email us at help@employmentlawyer.ca. Send us a brief email with respect to your situation, and I promise you someone will get back to you. I already see a couple of questions coming through, guys, and that's great. JC, I'll get to all of you guys in a sec. I just wanted to touch on one particular issue before we get started on the questions. I'm sure a lot of you are going to have questions and comments with respect to this issue, so I wanted to just lead the way with this, and that's with respect to these mandatory vaccination policies that we are seeing across Ontario, really, and across Canada, being implemented by lots and lots of employers. Now, a couple of points right off the bat, guys. When we're talking about vaccination policies, as with many things under the employment law banner, unfortunately, we as employment lawyers, and this is not just us, it's any employment lawyer for that matter, we cannot help unionized employees. It's unfortunate. I wish it was different. But if you are a unionized employee and you are dealing with a mandatory vaccination issue or really any other issue related to your work, you need to speak to your union about it. Your union is your legal representative as an employee, and they are the ones that will dictate what rights and what entitlements you have as an employee in the context of your employment relationship. You have to look to your union and to your collective agreement. And so, for a lot of individuals that are struggling with these mandatory vaccination policies, if you're unionized, your employment is going to be governed by whatever position your union takes. And so if your union is challenging these vaccine mandates, well, then great. If they are not challenging them, well, then you are going to be stuck as a unionized employee if you've been laid off or put on an unpaid leave. Now, for non-unionized employees, I want to be clear that employers that are requiring employees to be vaccinated, or alternatively then putting those employees that are not vaccinated on unpaid leave or terminating them for cause, those employees have rights. They are likely owed severance, and they're likely owed additional damages above and beyond that. And so if you are a non-unionized employee and you've been placed on a medical leave of absence, or excuse me, on an unpaid leave of absence, or your employment is being terminated for cause, meaning without severance, and quite frankly, even if your employment is being terminated without cause, meaning with some sort of severance package, you need to reach out to us right away. If you've been put on an unpaid leave, that is likely what we call a constructive dismissal. So you might have been terminated to begin with already, having just been put on a leave. If you've been let go, well, then obviously that's a very serious matter. You need to speak with one of our employment lawyers right away. Odds are you are owed severance. Every case is different. The analysis is always going to be very context specific. So it depends on your particular workplace. It depends on your age, your position, your years of service with that company. But if you are being let go because of these vaccine mandates, or you're being put on unpaid leave and you are non-unionized, you need to speak with an employment lawyer right away. It is absolutely crucial for your severance entitlements, potentially crucial for your career. So do please reach out to us. It is an issue that we're dealing with for the past several weeks, if not a couple of months at least, and it's going to continue to be a real issue as we move forward into the new year. So with that out of the way, guys, I'm sure you have questions about vaccine mandates and unpaid leaves of absence. So let's get into them. Once again, for those of you just joining us after right now, my name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, LLP. We are here to answer any and all workplace employment law related questions. So let's get into those questions right now. All right, JC is first in line. JC 2004 asks, is there anything that is not normally in an employment contract that a new hire should ask to be added to a contract when hired? Excellent question, JC. Employment contracts are there to limit the exposure and limit the liability of the employer. They are there to protect the employer. From an employee's perspective, I would actually, as strange as it might sound, I would actually prefer an employee start work with a handshake or with a very basic offer letter that sets out how much you're going to be paid, maybe what your benefits are, what your vacation is, and your job description. That's it. Anything beyond those very basic terms is going to be there to protect the employer. For example, a very lengthy, very protective employment contract, again, for an employer, will have termination language in it that limits your severance entitlements. It might have language about allowing the employer to temporarily lay you off. It might have language in it that allows the employer to change your pay or change your job description or change your reporting status or reporting relationship. There might be language in there about not soliciting clients if you leave the company. All of those items are there, and those are items we see very often in employment contracts. They're there to protect the employer. So to answer your question, JC, actually, no. I'd rather the employment contract from the employee's point of view be as limited, as bare bones as possible. That's how you as an employee keep your full rights when it comes to the employment relationship. Our employment laws, specifically in Ontario, although this is generally true throughout Canada, our employment laws are actually very, very protective of employees. And an employment contract will only limit those protections. All right, Carl, out of Vancouver, BC. Carl, thanks for asking your question. I will be let go on January 1st for not getting the vaccine. Non-unionized hotel worker. Should I get a sick leave note before I call you? They're asking me to get a human rights exemption and still need to be there every 3 days. Carl, whether you get a medical note or a sick leave note is going to be entirely up to you, and you might want to have a conversation with your doctor about it if you're feeling overly stressed or overly anxious and your doctor actually suggests and recommends a medical leave, by all means, take it. You should be following your doctor's advice, that's for sure. Will that help you with respect to these vaccination policies? No. At the end of the day, a medical leave won't necessarily, or a sick leave note won't help you with respect to these vaccine mandates. At the end of the day, an employer will be able to let employees go based on their vaccination status. We cannot stop an employer from doing that. We cannot physically stop an employer from imposing a vaccination policy and letting employees go as a result of it. However, Carl, what you can do then is pursue your full entitlements. And by that, I mean severance, and again, potentially other damages depending on the nature of the termination. And so, again, your job might come to an end, Carl, whether you take that medical leave or not. You can't physically stop your employer from terminating your employment, but you would be owed severance as a non-unionized employee, and your severance is going to be based on your age, your position, and your years of service with the company. If you'd like to have a sense, Carl, of what your severance entitlements are, pocketemploymentlawyer.ca. It's on the screen right now. There's a severance calculator there. We've had this severance calculator for years and years and years at the firm, and it will give you a very good sense of what your severance entitlements are. It's completely free, completely confidential. We don't take any personal information, and there's absolutely no charge. Input your age, input your years of service, input your position, and you will know what kind of severance you should be owed. Carl, if you're being put on an unpaid leave, or if you go on medical leave, or if your employer actually lets you go, you need to reach out to us right away. One of our Vancouver employment lawyers will be able to assist you, and do not just walk away. You are owed severance in your circumstances. Thanks for the question, Carl. All right, Kathy asks, is a verbal, I just lost it for a sec. Kathy, is a verbal job offer as binding as a written offer letter? And once it's been verbally accepted, can an employer rescind the offer? Excellent question, Kathy. Yeah, a verbal job offer is just as effective, and a verbal agreement is just as binding as a written one. Your problem, Kathy, may be evidence-based in that, well, a written contract and a written agreement is there in black and white to see. A verbal agreement or a verbal offer and acceptance may be a problem because the other party may have a different story. They may lie, or they may have seen the situation differently than you, and now we have a problem of evidence. If you have been offered a job and that job is then rescinded, and you have suffered a loss because of it, maybe you resigned your old job because you accepted this new job, there might be damages owing there. There's potentially a legal claim there, Kathy. So if that's your situation, do make sure you reach out to us. Contact us off air. Let's have a conversation about it, and I'm sure we'll be able to assist. Again, even if it's verbal, that still counts. That's still a binding agreement. Valeria asks, hi, Alex, can my employer refuse to pay my vacation bank during the unpaid leave due to the vaccination policy? Valeria, it's a question I've gotten lots over the past number of weeks. For some reason, employers are giving employees a hard time because of this, or on this issue of paying out vacation pay. I think because they're trying to really put pressure on the employees. And that's completely unfair. I think employers should be paying out vacation if the employee asks. I think your bigger problem, however, Valeria, let's forget about vacation pay for the moment. If you're being put on an unpaid leave, that's a problem in and of itself. That leave may be what's called a constructive dismissal. In other words, it might be a termination in and of itself. Listen, if you're accepting the unpaid leave and you just want the vacation pay, sure, you can deal with that. But again, I think there might be a bigger issue at play here. You might want to deal, with the actual unpaid leave itself. You would potentially be owed severance in that situation. And not only would you be owed that severance, you'd be owed your vacation pay over and above that. Keep in mind, vacation pay is separate and apart from any severance entitlements. When an employee is let go, they're owed their severance, but they're also owed their vacation pay, again, over and above their severance entitlements. Baby Cakes, great name, asks, if the company is assisting medical exemption people get remote jobs but not helping religious exemption people, would that be discrimination? It depends on whether the exemption is legitimate or not, Baby Cakes. Unfortunately, in Ontario, the exemptions may be quite limited, both for religious reasons and also for medical reasons. So that might be a tough claim to establish. Certainly, if your religious exemption, if your religious claim is legitimate, then listen, regardless of what they're doing with respect to medical exemptions, that might be discrimination in and of itself. But again, we have to discuss and we have to weigh the validity of the religious exemption. And I've spoken to a number of people over the past few weeks with respect to religious exemptions and assisted people in exactly that situation. So you might want to get advice. You might want to reach out to us. Again, the website is employmentlawyer.ca and the email address is help@employmentlawyer.ca. Again, you could send us a brief email and someone will get back to you. Sabrina asks, I've been terminated this week for not following the policy, in quotation marks. I think I know what you mean, Sabrina. I asked for a copy of my employment file. They have denied me access as I'm a former employee. Is this correct? Can they withhold my personal information? Sabrina, it's not correct. You should be receiving all the contents of your employee file or your HR file. Those are effectively your documents. You have every right to them. Of course, the bigger issue here is that you've been let go. Sabrina, if you are a non-unionized employee and you've been let go for not following a vaccination policy, as long as there is no government mandate in place. So for example, if you are a long-term care employee, that might be a problem because in Ontario, at least, there is a government mandate in place with respect to long-term care facilities. If that's not the case for you, Sabrina, and I imagine it isn't, I imagine there is no government mandate because there are really not many. Long-term care is really the only one. Then you are owed severance as a result of your termination. Unfortunately, we can't get you your job back, but you are certainly owed severance based on your age, position, and years of service. If you're a long service employee, you could be owed as much as 24 months of pay. That's 2 years of pay. So do be sure to reach out to us. Visit the Pocket Employment Lawyer to get a sense of what your severance entitlements are, and certainly contact us by going to our website, employmentlawyer.ca. Anna asks, my employer put me on a temporary leave April 15th, so it's quite some time now. Another employee who has a lawyer got a response back from the employer saying a constructive dismissal does not apply because of IDEL. Anna, great question, and refreshingly, not a vaccination policy question. It's a question with respect to temporary layoffs. Anna, I could tell you that these IDEL leaves, and what that stands for all of our viewers, is Infectious Disease Emergency Leave. It is a type of leave in Ontario that is effectively kind of a COVID temporary layoff. Anna, that only applies if either you have an employment contract that allows an employer to temporarily lay you off, or you have been subject to temporary layoffs in the past. So your employer's position or your employer's lawyer's position may very well be, and likely is, incorrect. They are obviously saying that because it benefits them, but that is not necessarily the way the law works. We actually have a couple of decisions already in Ontario that have confirmed that these temporary layoffs, these IDEL leaves of absence, are terminations. So Anna, your employer is likely incorrect. If you're in a situation and you're on leave, do be sure to reach out to us. Let's have a chat. Let's talk about what your options are. It might make much more sense to claim constructive dismissal, to claim a termination now, rather than waiting around to be called back to work. But we can discuss those off air. Let's have a chat, and it's certainly worth a conversation. Please do reach out to us. Lisa asks, do you help people who have been on unpaid leave due to the government vaccine mandate? Lisa, if you are in one of those industries, and again, long-term care is one of them, with respect to federally regulated employees, the airline industry might be another, or maybe the transportation industry more generally. But Lisa, if there's a government mandate in place with respect to your particular industry, your particular workplace, listen, we can certainly have a chat, and it might be worth getting legal advice in your situation. Actually, it is worth getting legal advice in your situation. However, for those employees that are subject to a government mandate, that might be an issue. We don't, as employment lawyers, pursue the government with respect to these issues. and a government mandate kind of absolves your employer from any potential liability, which puts you as an employee in a tough spot. It is worth knowing for sure, Lisa, so we should have that chat. But again, if there's a government mandate in place, you might be stuck. You might be either forced to accept vaccination to continue your employment or risk being terminated without any severance. Again, guys, this is for employees in workplaces where there is a government mandate in place, and they are few and far between. Most industries, most workplaces do not have a government mandate, whatever your employer tells you. Julie asks, can EI deny a claim due to not following the vaccine mandate? Great question, Julie, and that is currently the position EI or Service Canada is taking, that if employees are being laid off, put on an unpaid leave, or terminated for not following a vaccine mandate, they will not receive employment insurance. Now, the bigger issue there, Julie, is, well, if you are looking for a record of employment or looking for EI, it means that you've been put on an unpaid leave or that you've been let go. And again, if you're a non-unionized employee and there's no government mandate in place, well, then you should be pursuing not only a proper record of employment that would allow you to receive EI, you should also be pursuing your severance entitlements at the same time. I can tell you, over the course of years and years and years that I've been practicing, as part of many settlements where a for-cause termination is being alleged, we are able to negotiate as part of a settlement a proper record of employment that then allows the employee to receive EI. So that is something that is definitely doable as part of negotiations. Julie, you can't do that on your own, unfortunately. You need assistance and advice from an employment lawyer. And so again, do reach out to us. All right, as Azael asks, my employer has a clause in my work agreement about limiting my severance to ESA minimums. Is there a way to negotiate this contract without losing the job offer? Azael, great question. If you are being offered this as part of an offer of employment, so if you're not yet employed by the company and they've offered you a job, yeah, I think that's definitely negotiable. Of course, keep in mind, Azael, that negotiation comes down to whether an agreement could be reached. So if I was you, I would certainly suggest amendments to that paragraph. Perhaps there's a formula that you can suggest, and we do this all the time as part of employment contract negotiations. We suggest some sort of formula that makes much more sense for the employee. However, keep in mind, Azael, that your employer or the prospective employer might refuse to negotiate. And at that point in time, well, if they refuse to negotiate, you have to decide, do you want the job or not? A note for employees that are already employed and they have an employment contract with a termination clause in it. So with termination language in it that speaks to what they might be owed in the event of a termination. Keep in mind, everyone, that just because that language exists in your contract, it doesn't make it enforceable necessarily. A lot of contracts that we see, actually the majority of contracts that we see that have termination language in them, they're actually not enforceable. And that means that an employee is still owed, despite the language in that contract, they're still owed their full severance entitlement. So don't just assume that the language in your employment contract limits your severance. You need advice from an employment lawyer. Chances are you can still negotiate a better severance package, even if your contract contains termination language in it. Guys, I love the questions. Keep them coming. Unfortunately, we are running out of time, so we're going to do some rapid fire Q&A for the last 5 minutes of the segment. If I don't get to your question today, there's going to be another live Q&A tomorrow. And again, guys, keep in mind that you can contact us off air at employmentlawyer.ca, at help@employmentlawyer.ca, and just go on the website and you'll see our contact information there. Do not be shy to reach out to us, even if it's off air. All right, guys, let's do this rapid fire session. Tiffany asks, in Ontario, can my private workplace that is federally regulated make me take the PCR test on my own time? There's a policy that says that I have to take it twice a week and done so on my own. No, Tiffany, is the short answer. Rapid tests might be more reasonable. Certainly on the employer's time is more reasonable. It also depends on whether you're unionized or not, but I would say the short answer is no. Grace asks, contacted your firm for advice and was offered a paid consultation. Would that be because I asked a more specific question regarding my situation? Grace, what I will say is, listen, every situation is very context specific. Most of the consultations we will do for free. However, some matters are, quite complicated, quite lengthy, and that usually means that we would need a fair bit of time to actually give you proper advice. And in those situations, it may very well be a paid consultation. What I could tell you, Grace, is almost always, if not always, it is certainly worth the cost and worth your time. If you have any concerns, don't be shy to contact us. Send us a quick email, and we can get into more details off air. But I think that's the proper advice. Mike asks, why is my employer denying my religious exemptions? I have the Liberty Coalition of Canada religious exemption letter, which is printable online. Mike, be careful what you find and what you use online. Just because you found it online and it looks like a kind of formal letter, it doesn't mean it's a proper religious exemption. You need a letter from a local religious leader that ideally you have a strong relationship with and that supports your claim. If it's just a letter that's printed offline randomly somewhere, it's not going to do the trick. It won't pass the test, and I fear that that's your case. Wanda asks, my employer has an association, not a union. Would it be the same? Wanda, it might be the same. It depends on whether you have a collective agreement. If your association has a collective agreement, unfortunately, we cannot assist. Shar asks, isn't it discrimination to let someone go because they didn't take the vaccine? Shar, it might be, it might not be. It depends on the circumstances of the termination. There might be, in the case of maybe a medical exemption, a very strong discrimination claim, a very strong human rights claim. There, it may also not be. Azael asks, you can request your HR file just by asking. Yes, you can absolutely request your HR file just by asking, and your employer should definitely provide it to you. Kathy asks, my current position is unionized. However, the verbal offer was rescinded. Was for a non-union position. It's the same company. Would your law office be able to help me? If you are unionized, Kathy, but what you were being offered was a non-union position, then we may not be able to help. You might want to speak to your union first. If your union says this is a non-union matter and you should get some individual advice, then perhaps we can have a conversation. Kathy, there should also be a potential loss there. I want to remind you. So if you haven't really lost anything besides a kind of potential a non-unionized position, there might not be there much to pursue there. Helen asks, a couple of minutes left, guys, so I'm going to get to all of these questions, I promise. Helen asks, my supervisor took away 3 of my shifts to give to someone else. States that because I don't pick up extra shifts. I've been doing the same shifts for the past 10 months. Can she do this? Excellent question, Helen. If taking away 3 of your shifts means that it is kind of a permanent thing, so if they're taking away 3 shifts a week indefinitely now, and that means that maybe you're going from, 40 hours a week to 20 hours a week. That is a significant change, Helen. And yes, you absolutely can do something about that. That is what we call a constructive dismissal. Your employer is basically reducing your hours and therefore reducing your pay in a significant way. If you're losing 1 or 2 hours a week, listen, that might not be significant enough. There might not be much to do in a situation like that where the loss is very, very small. But where the loss is significant, is substantial, and it sounds like 3 shifts a week is pretty substantial, that is a problem, and that is, again, likely a constructive dismissal. Helen, before you do anything, before you even speak to your employer about this, you need to get legal advice right away, and you need to move quickly. If you take too long, your employer might think that you accepted the change, and that might be a problem. So do reach out to us right away, speak with one of our employment lawyers in whichever province you're in, and we will be able to point you in the right direction and give you the right advice. Tiffany asks, my workplace is treating my team to a nice meal at a restaurant. I'm losing out because of this opportunity because I cannot attend due to my medical status. Is it discrimination to lose out on perks? Unfortunately not, Tiffany. I mean, not in this context if the perk is a restaurant meal. Every situation is different. So if you are being punished because of your let's say, a medical disability, and maybe you're not getting a bonus for that reason, well, then that's potentially a problem because it affects your financial compensation in a significant way. But a meal at a restaurant, no, unfortunately not. All right. Cindy asks, how much is it going to cost me to fight for full severance? Do you offer free consults? Yes, Cindy, we do offer free consults. Consultations are not free in every single case, guys, just to be aware. But if your matter is straightforward enough, yes, we do offer free consultations. A lot of our matters we will take on what's called contingency, which means that you won't pay us unless we actually obtain a settlement for you. Although, again, Cindy, not all matters are taken on that basis. And so, again, every case is specific. Do not be shy to reach out to us about this. Let's have a conversation. We will help as best that we can and figure out what we can do for you. And so, a lot of times we'll be able to do this kind of stuff for free, guys, but not always. Ask, reach out to us, and we will help you as best we can. We will wrap it. Haven't gotten to your question, tune in tomorrow at 1 p.m. For the next session of Employment Law Q&A. Once again, my name is Alex Lucifero, employment lawyer with Samfiru, Tumarkin, LLP. It's been another great edition of Employment Law Q&A. You guys have asked some great questions. Hopefully, I've pointed you all in the right direction. A lot of mandatory vaccination stuff. We will see that continuing over the next several weeks and months. Until next time, guys. Take care. Have a good rest of the week and an excellent weekend. We'll catch you next.